Listen, if anybody out there likes collection agencies calling you up here, I think you're into pain, okay? So nobody enjoys it, especially when you're trying to sit down for dinner. But the question is it worth $83 million? Well, a jury in Missouri awarded just that amount of money to this woman on the screen. Company trying to collect $1,000 from her, but it was going after the wrong woman. She didn't owe them a cent. Now, the verdict, it called for $250,000 in damages plus $83 million in punitive damages. All right, now, I go in with trepidation with Doug on this because the last time I talked about, I think it was the Starbucks thing, he literally inhaled me and said, "How dare you?" Man speaking for the proletariat, I ask you this. We saw what happened actually in the Starbucks case that got tossed out. You're the attorney in the case, and you're defending this woman who obviously was wrongfully harassed. Nobody should be harassed that way, but she certainly was. Do you say, "Oh, Jesus, they just gave us $83 million, or do you say, "Yay," because you know you're never going to collect it? Is a more practical sum, especially given the pain and suffering, if you want to call it that, better off for not just her, but the attorney who tried the case?
Well, no. I mean, you have two things here. You have the $250,000 in damages, and then you have the $83 million. And that's directed at this company for doing bad things, right?
Yeah.
So the jury actually listened to it, and they thought there was $83 million worth of bad things.
But that's ridiculous.
It is. But there's going to be a trial judge that's going to take a look at this, and the trial judge is going to have the ability to knock that number down to whatever they think is appropriate. Then there's going to be appellate courts that could do it again. So you'd rather start with a high number. Listen, you can't discount.
But isn't there a better chance, I'm sorry to interrupt, if the number is more modest? Let's say they said $3 million, okay? There'd be less of an incentive for the company to appeal the decision, to fight this way and go through 6 different trials or whatever. $83 million, even if the judge cuts it by a third, right? Or cuts it to a third of it, there's still incentive to keep fighting this thing. Doesn't the number have to be a more practical one that the attorneys for her and the attorneys for the company sit down and say, this is what we'll pay, this is what we'll do?
Well, listen, these corporations, they don't want to pay anything. So if you think that a reasonable number is going to help them, they're going to take that number and say it's high no matter what. So you might as well start with $83 million. Now, you're supposed to, in our legal system, you're supposed to have deference for a jury. This jury spoke, and the judges have to listen to that also. They can change the number, but there should be a certain amount of deference to a jury. If they said $83 million, that judge has to think long and hard.
Every case is different, but realistically, how much money at the end of the day, if form holds, will she end up seeing?
I would have to look at the jurisdiction, find out what the sustainable limits are in that jurisdiction, and it should come in somewhere around that.
All right. Now to a story about the rights of a tenant, and it deals with privacy, of course. Ricky Wright got a 15-year prison sentence for drugs and weapons charges. Now, the police arrested him after his girlfriend's landlord let himself into her apartment to try and fix a leak. When he walked in, he saw drugs, guns, and he called the cops. Police did not have a warrant. Now, the New Jersey Supreme Court just ruled something like this cannot happen again from now on. Police, they're going to need a warrant to search her home, even when a landlord enters first and spots something suspicious. Okay. He didn't go in just because he was a peeping Tom and wanted to go into the underwear drawer. He went in because there was a leak. Now, when Briscoe asked the landlord to let him in, the landlord, if he'll open the key, everything at that point is fair game. What is the rule in terms of what can or can't be admissible, even if you don't read and get permission from the tenant themselves?
Well, what should have happened here is if the landlord's going in with a good faith reason to fix a leak,
yep,
which the landlord presumably has a right to do, especially most likely under the lease, and that landlord sees drugs or some other contraband, the landlord calls the police. What should have occurred at that point is that landlord would have become a confidential informant. You go to a judge, you apply for a warrant, and you go in and you get it properly, and that way you don't have any of these issues. That's what should have happened.
What if they go through all that, and in the meantime, the guy comes home, puts 2 and 2 together, takes all the drugs and the guns out of the apartment, basically got away with being a drug dealer?
He probably would not have under those circumstances, because if all you're doing is going in to fix a leak, you're not disturbing anything else in the house. They may not even know you were in there to fix the leak. And you could call the police and say, listen, this is what's going on. Normally, you can go in without a warrant if there are exigent circumstances. Something's going to happen that's going to be immediate, but that probably is not the case here.
Isn't this a distinction with a difference? Mark, in that they didn't kick the door down in the dead of night and start rummaging through the guy's thing.
Well,
They were basically asked in by the owner of the property.
Right.
Again, this is not the owner. The landlord let in the police to a tenant's apartment.
right.
And the landlord had his own key.
Basically, the U.S. Supreme Court has something called the private search doctrine, which is if the police get evidence from a third party, a private citizen, there's no exclusion of the evidence because suppression is supposed to deter police misconduct. This is a new rule announced by the New Jersey court under the New Jersey Constitution. So the police previously would have had no notice that this conduct
And
was
by the way, does this
unconstitutional.
work going forward?
That's why it's going forward, because it's a new rule announced
So this
under the New
evidence
Jersey
is still going to be
Constitution.
admissible
Yeah,
from
in
what
all
they did.
likelihood. I haven't read the full decision, but I know about it.
Although state law, again, the constitutional law, the federal constitutional law is a floor. So states
That's
can
right.
make it greater, they can
That's
add
exactly
more
what they
burdens
did.
on law enforcement.
That's exactly what they did going forward under
This is
the
a
New
big
Jersey
issue,
Constitution.
privacy, that you deal with,
Absolutely.
not just on the broader level, but in terms of what's admissible, what's not, what reasons, reasonable expectations of
Well,
privacy
this is
people
why
have.
Google and Facebook are fighting so hard in Congress right now not to be tools that are subject to mandatory compulsion by the Justice Department, because they're essentially private entities that are being co-opted and enlisted by the
In many
Justice
ways,
Department
they're
to
the
help them.
landlord in this case
That's
here,
right,
as to whether or not they're going to let people in
That's
the
right.
apartments.
Now, under in the old days, the phone company had to produce things in response to a warrant from the government under Title III. This is a brave new world with the internet, and that's why Google and Facebook, in their own profit motives, are essentially fighting for us and for themselves.
Gentlemen, thank you very much. Leave it on that note. All right, when we come back, I'm going to take a look at some Hudson Valley headlines. Please stay with us.